call from wherever you're tuned in. Welcome to another episode of Digital Service Conversations. This one, we stopped counting. We are now counting years instead of which episode. But on this special episode, we are hosting Mr. Deo Kalikumutima to talk everything regarding land, certificates of title, the land registry, special titles, land fraud, and whatever questions you have on land. So if you have joined the space, you have joined just on time. Our guest, I know is known as a lawyer, the land expert, but this question we always want to manage the guest. So apart from Kalikumutima, the lawyer, I think my first question will be to Mr. Kalikumutima, who is the people on call want to know who is Mr. Kalikumutima Deo, what makes him tick, what has his fire burning in the morning, and what really makes him wake up in the morning even when he doesn't feel like going to work at that particular day, besides being a lawyer. Who is Deo Kalikumutima?
Thank you so much, Alfred. It's a pleasure to be here. Nobody can stop reggae, right? For our viewers and listeners, wherever you are, especially for my Uganda family, my diaspora family, Kalikumutima Deo, here joining Alfred and Tim. It's an honor. Kalikumutima Deo is a Christian. I say that fondly. I'm a Christian, I'm a humanitarian. You can see the badge here. I'm a Rotarian. I believe in making a difference in society. I'm a family man, and I thank God for that. I love music, Alfred. I love music. I love gospel music. I love jazz. But we're not going to talk so much about me because of time. Professionally, I have the humbling privilege of leading the team at Kalikumutima and Company Advocates, where I serve as the chief executive partner. Kalikumutima and Company Advocates is a corporate commercial practice located at plot 14 Clement Hill Road. We are a team of 45 dedicated professionals, a multidisciplinary team with 3 branches in Uganda. We also have a branch in Mbarara at Adit Mall and a branch in Mbale. We have diaspora affiliations in the US, to mention but a few. We are members of the Worldwide League of Independent Lawyers. We are members of the Private Sector Foundation. What makes me tick? That's a unique question. Service, my desire to serve. My desire to serve as a professional, first as a Christian, as a family man, as a humanitarian, but also as a professional. I believe so much in making a difference as I execute my duties, as I serve my God, as I do philanthropy work. I believe so much in impact. I believe so much in value. I represent credibility, credible relationships, integrity, character, and value. I could go on and on. But today is not about titles. Alfred, thank you so much. Allow me add that most importantly, I'm here to talk about life. And indeed, land is an integral aspect of life. So let me stop there.
You can, you can join me. So, just as from there. No.
Sorry for coming in late. Good morning, good afternoon, and good evening to whoever has joined us from wherever you've joined us from. And I think we've learnt the critical aspects of life from Mr. Deo Kalikumutima. Deo, welcome again to the Judicial Service Conversations. I'm sure my colleagues have welcomed you. And I think I'll start from the most basic question. Yeah.
Yeah, I answered it, but you can
Huh?
proceed. You can proceed.
I'll start from the most basic question. We hear about fake titles, duplicate titles, overlapping titles, special titles. Take us through the certificates of title. You know, think about it. Someone is listening right now who is in the middle of a shocking dispute. Someone is from the diaspora, is buying land. He's seen the title, it says special certificate. He has read a note from the minister. And is it a directive? What's the directive? A what? An order from the minister saying that those titles are not to be issued anymore, outlawing. Someone is told he hears what they call a duplicate. They tell him your title is a duplicate. Everyone who is listening to us, if you have a title, it's actually a duplicate, just so you know. But anyway, so they will tell us they are duplicate titles, special titles. There's those which are overlapping. The new vision called me yesterday and said, what happens when there's a Milo and a freehold that are overlapping? So what's overlapping? And what I want someone who is listening to get scared. What should scare them?
All right, looks like someone is banging the tables. Allow me split the categories here. Thank you so much, my brother Elson. I am glad that you joined us. We need to understand what a title is, and specifically what a certificate of title is. And I'm not going so much into legalese because we have so many land lawyers in our audience. But under our laws, specifically Section 59 of the Registration of Titles Act, a certificate of title is conclusive evidence. Evidence, and emphasis is on the word evidence of ownership.
It is conclusive
Evidence.
of ownership.
However, there are exceptions to that. So we are looking at evidence, key. Number two, we are looking at an enabling factor to continue land ownership, and specifically titled land. You cannot transfer a legal interest without a certificate of what? A certificate of title. Now, in Uganda, we operate the torrent system. We have a registry file, and that is where the word duplicate.
Just repeat the name of that system.
Torrents. This is imported. Yes, and it is imported. It has been applied here over the years with the necessary modifications.
Okay.
Now, for every title, there is a record. And this is how the record is constituted. We have the registry file. In the case of Milo, the white page. In the case of Milo, we also have a duplicate certificate. We have a duplicate certificate of title.
So if I have a Milo title, just slow down. If I have a Milo title, there is a Milo registry, and there is the title I'm holding is called a duplicate.
A duplicate certificate of title. And why it is called a duplicate? Because the registry copy, which is the white page,
Is the original.
It exists on the... No, both of them are originals.
Okay.
Both of them are originals.
Okay.
There's the registry file that has the white page. Now you have the duplicate certificate of title.
Yes.
And please note that the two records have to speak to each other.
They have to match.
So when you're talking about completeness of the record, the two have to mirror. What is on the white page has to be on your duplicate certificate of title. Now, allow me emphasize that duplicate does not mean that it is a photocopy. It has been misunderstood that because it is styled duplicate, it is a photocopy. No. It is called duplicate because there is another record on the other side. Now, we have defined what a title is. We have talked about a duplicate certificate of title. I've also had people talking about fake title. So allow me also define a fake title. And please note for our audience, whatever I'm expressing here is my opinion. It is not Elson's opinion.
No,
It
you're,
is not an
you're
opinion.
expressing the law as it is.
The law as it is.
And as you understand it.
And I'm not speaking on behalf of Ministry of Lands or the what?
Or against.
Or against other minister. No. I'm relaying the facts as they are. A fake title is forged. It is not authentic. It does not speak to the other record on the side of the ministry. If it is Milo, it does not speak to the white page. If it is freehold, now for freehold and leasehold, we have the registry copy and the owner's copy. That is for leasehold and freehold. Again, for the benefit of our viewers, in the Republic of Uganda, the Constitution does provide for different interests. We have customary, we have Milo, we have leasehold and freehold. Milo and freehold are permanent interests. A lease is for a fixed period of what? Of time. Now, for a lease and freehold, we have registry copy and owner's copy. Now, allow me quickly go to, a freehold.
So you can show us. You had brought
Yes.
for our YouTube audience. Maybe you can just show it to the camera. This is a. For those of you who are on
This
X,
is a freehold certificate, my own. I have not carried someone's.
your wealth is here. You have only on the JSC conversations people come with their wealth.
This is a freehold
Uh-huh.
certificate of title. But for purposes of this discussion, this is a photocopy.
Yes.
Okay? And you'll see at the bottom you have owner's copy there.
Yes.
Owner's copy. Why this is an owner's copy is simply because there's a registry copy on the part on the side of Ministry of Lands. Allow me quickly go through certain features. When we are talking about, you have fake on one hand and then you have authentic. There are certain features that you need to look out
So
for.
if someone is giving you a title, there are features you should look out for.
There are features that you should look up. I don't know whether I'm setting my own questions.
No, you're doing very well. They're much better than the ones we had given you.
So, allow me salute the government and General Yoweri Museveni. This is not political, but we must give credit where it is due. In 2012, Ministry of Lands digitized. We operated manual records for the longest time possible. We have the first surveys carried out as far back as 1908, first title issued way back. Now we have digitization happening. That is why we have these beautiful land titles now. You see this? This is a security feature. If you scan this, you'll get the basic
What's
detail.
the security feature? So someone is on X.
Someone is on X.
He can't see you. Someone is on YouTube. First of all, to the YouTube guy, first show us, then X guy, we're coming to you.
Barcode
There's a barcode.
on the title,
on the
which
title.
is serialized. When you scan it, I'm not an expert on phones, so I'm going to speak to the phones that I carry, an iPhone or a Samsung, but I know different kinds of phones. No. These are facts, Elson. So if you scan this, you're going to get the basic information.
Now Joy is lost.
You're going to get the instrument number. An instrument number I'll talk about at a certain
Yeah,
stage.
we don't have to go into so much technical details, but just so we are clear, you just show us on the thing where the barcode is. And now if you're on X if you have a certificate of title on the top left hand corner, there is a, what did you call it?
For simplicity, let's call it a barcode.
A barcode.
Yes. A security mark.
Yes.
This system was introduced to do data cleanup, to integrate, move from analog to digital, but also to fight fraud. So this is a security feature.
Okay.
When you scan it, you will see the instrument number.
So if some guy comes to you with the title, the first thing is you scan.
Yes, but allow me quickly qualify my statement.
Yes.
Digitization is a process, and it is still ongoing. Like I said,
So
these records...
So those clever people in Ministry of Lands have not updated the system.
No. They have updated the system, but we have so many records. We have so many records. So for the newer titles...
You can say it diplomatically. For us, we shall be rude. Those clever people in Ministry of Lands.
So please take note. There is also a seal. You cannot see the seal here.
On the
Now,
title itself.
On the title itself. Each
Yes.
zonal office has a seal. And that seal has key features. Of course, the brethren... No.
Yeah, the
Our
brethren.
friends at Nasa Road and Nkuruma Road are fairly smart, but if you look at these seals critically well, there are features that I will not disclose here.
Disclose.
No.
Oh,
There-
the
there are
other guys may be
yes.
listening.
So there is a seal, you have that security code.
Potential clients may be listening.
Yes. Then it has the ownership details, it has the signatures of the registrars
Yes.
and their stamps. Now, I thank God that this is my second decade of practice. So I have interfaced with the Ministry of Lands for a fairly long time. We actually get to know some of these signatures. I'm not a handwriting expert. This show is about logic.
Yes.
We are applying logic and common sense here.
Yes.
Yes, people have mastered the craft of forging these signatures, but you have an idea. I know how Elson's signature, at least I have a fair idea. So before I take it to the handwriting expert, I'll say, no. But
whose
this
signature is
signature,
this?
honestly, no. For example, the commissioners, I have interacted with Mr. Tivisas, I retired, Kulata is now in private practice, the late Kadwe. So you get an idea about the different. So the signature is, now in the absence of all this, and please note, the two records have to speak to each other. If they do not fake. Now quickly to special certificate of title. The law, I said I will not go legalese, but allow me address the law to a fair extent because I respect it so much. The Registration of Titles Act, specifically section 69, talks about a lost grant. If you lose your title, if your title is obliterated, if your title is destroyed, if it cannot be used, the law allows the registered proprietor to apply for a special certificate of title. Now, allow me quickly note, and I really didn't want to talk about that directive that you are talking about, sir. But now you've lured me into the discussion.
Yes.
Under the Constitution of the Republic of Uganda, specifically Article 26, Ugandans have a right to own property. Okay? Under Article 40 of the Constitution of the Republic of Uganda, Ugandans have economic rights? A right to trade. Now, it is my right, if I lose my title, or if it is unusable or obliterated, to apply for a replacement. That is a special certificate of title. And the law does provide, for a mechanism, a replacement mechanism, procedure or process. Now, special certificates of title per se are not bad because, like I said, we have rights. The law gives us a process within which to recover. But the process has been abused for the longest time possible. That is why some, including myself, when we see a special certificate of title, we say red flag. But again, in that process, you must account for the loss. There has to be a statutory declaration. Where you are accounting for the loss, you must produce a police report. And I thank Ministry of Lands for putting in place measures. At least to some extent, they have measures in place. You make your application, there's a statutory declaration, there's a police report accounting for the loss. It is verified. Once verified, a notice is issued. The notice runs for 30 days in the Gazette. Now they have taken it to a new level. They also require you to advertise in a newspaper of wide circulation, like the Daily Monitor, the New Vision, and also on X. I was actually surprised. I was going through X, I looked at the hand and said, oh, okay, this is good. Why do we have this notice? It is notice to the whole world, again to check fraud. But I'm not going to set my own questions. I think for now, let me stop there.
No, but what maybe you can close on that point. So the directive has come from the minister. Maybe for those who don't know about the directive, I don't know if you've seen the directive.
Yes, I have. And I wrote an article in response.
So you can tell us briefly what the minister has directed. You have told us about section 69, and we want to agree with the minister.
You want to bang the tables?
No.
Again, this is my humble and considered opinion. But first, the minister did direct that in order to check abuse of land administration and having noted abuse of the process leading to the issuance of special certificates of title, the ministry has halted issuance of special certificates of title for 3 months till December, as they revisit, review, rethink the issuance. Now, for us practitioners, we got concerned, especially for those of us in the corporate commercial space. Like I said, I'm setting my own question.
No.
I will note that the intention and the spirit of the Honorable Minister of Lands is okay. Okay?
She has a
There
good
is-
intention.
She has good intentions, bless her kind soul. However, we are setting out to treat a symptom. We have a bigger problem.
Yes.
So we need to address the elephant in the room. God forbid you have malaria. Yes, you can swallow the painkiller, okay, to take away the headache. But the Panadol is not going to take away the malaria.
The plasmodium.
Yes. Now, here's the catch. Ministry of Lands facilitates trade. So, the property markets are affected. Government revenue streams are affected. But most importantly, rights, and now I'm looking at the innocent, I see some innocent faces in this room. I'm looking at innocent Ugandans who would like to trade but they cannot. For example, the banking sector. The real estate sector contributes 11 to 15% to Uganda's GDP. Now, land is a key component. So when you say you cannot issue special certificates of title, there's a big challenge. And guess what? Section 70
Okay, section 70.
of the RTA gives us a bigger challenge. The courts of judicature can direct a register of titles to issue a certificate of title. It also has its process. So
Okay, maybe let's just understand. Maybe if you could mute. Maybe so. Let's just understand. We have the section 70 of the law, which provides for the court directing, for example, if they cancel your title, they can order them to issue another one. But on this issue of special certificates of title, apart from the Honorable Minister's great intentions, it would be correct to say that the RTA does not give her that power. She must exercise legitimate legal authority. We had a minister here last week and we asked him, what's your power? The man opened for us books and started reading for us powers. We said it's okay. Does this one, if this one were to open books, could she read for us that, or he, would they read for us that power?
you know,
I hope I'm not putting you on the spot.
no. This is a logical discussion.
Yes.
This is a logical discussion. We are not about politics. We are about reality. To the best of my knowledge, the Minister of Lands does not have the power to curtail the Constitution of the Republic of Uganda, does not have the power to curtail the rights enshrined in the Registration of Titles Act. Yes, the law does allow a minister to make guidelines. But where you have a statute following the constitution of the land, what Alfred and his dear young lawyers call the grand norm, the minister does not have power to curtail that. You cannot. Like I said, you have a right to own property. You have a right to trade. And the law says, if the title is lost, replace it.
Yes.
So, it is my humble opinion and submission that she does not. She does not. It is very clear. Intentions good, modest. Wrong. Not poor, wrong.
Wrong.
Yes,
Much
wrong.
obliged. Much obliged. Much obliged.
I could continue, but I'm looking at time, so
Okay, maybe.
But the issue of special certificate, let me talk about Section 70.
Yes.
And it is very important.
And this is Section 70 of the Registration
of Titles Act, Cap 240.
So CAP, for those who don't know, is a chapter 240 of the laws of Uganda, 2025 edition, is it?
As amended. 2024. Yes.
2024 as amended. I'm guided.
I was trying to keep away from the legalese. I guess we cannot.
No, but I just wanted the people to know that the law of Uganda has chapters.
Yes, we do have chapters.
Uh-huh.
We do have chapters. Now, Section 70 puts the commissioner, land registration, and the titles office in a very tight spot, because the courts of judicature can direct, order the titles office to issue a special certificate of title. Now, on one hand, you have the honorable minister saying, do not issue. Now, you have a court saying, I direct you to issue. You do not issue, contempt of court. I'll file my application. So now, the liability that is supposed to be specific, interestingly, again for emphasis, the liability is specific to the registered proprietor. Why? Because on oath in their statutory declaration, they have accounted for the loss of their title. So if anyone has told lies and what Section 7 of the Statutory Declarations Act, they can be held liable and convicted 3 years in what? In prison. The law has a forum for what? For that. Now you're putting everything on hold. You're telling the commissioner, do not issue special certificates of title. Here is this commissioner directed by court saying, now issue the special certificate. You don't, Elson runs to court, files for contempt, you get an order against the commissioner. Do you see the conundrum?
Yeah.
It puts us in a very unpalatable situation because we are fighting hard to treat a symptom.
Yeah.
We need to go for the elephant in
The room.
I'm sure at a certain point you'll ask what that elephant is.
Yes.
Yeah.
Okay.
And again, please allow me add.
Yes, please add. Please add.
At some point, maybe we may talk about estates, letters of administration. How many grants are forged? So many. It's part of the fraud. So should the Chief Justice come out and say, now, henceforth, the courts of judicature shall not issue grants because they are forged? Because there's fraud? Are they going to do that? No. They can't. They need to address the bigger what?
What's
the bigger challenge.
They need to defeat the fraud.
Yes, they need to. Look at district land boards. A lot of fraud in that area. Should the Attorney General wake up and advise government and say, you know what? Let us scrap up off all district land boards. Now we have solved the problem. No. That won't cut it.
If you're just joining us on YouTube, or on X, welcome to the Judicial Service Conversations. We're talking land, we're talking titles, we're talking special certificates of title, we're talking fraud, we're talking the registry. I think it's a fantastic conversation. You know, the law, there is the law as it is, there is the law as it should be, and there's what happens on the ground. And many times, the administration of land first divorces itself from the law, and it is that divorce that allows in fraud. I want to submit that part of the fraud problem is the problem of the failure to adhere strictly to the provisions of the law, because the law actually on registration of titles is very clear. And how can we use technology to enhance it and all that? Our questions will come to in the course of the conversation. But now I want to go to my colleague Joy. There you may or may not know Joy. She's a very serious Ugandan citizen. She used to appear on the TV, radio. Now she appears on the Judicial Service Conversations, which is the most serious conversation now happening in the country. But also, You've talked about dear young lawyers. She's also dear. She's also young. So maybe Joy, over to you. You can fire away.
Thank you, Ellison, for that. And to our listeners and to our viewers on YouTube, we're very delighted to have you. Thank you for joining us every Wednesday for the Judicial Service Conversations. And definitely, nobody is stopping this reggae. We are very delighted to be discussing land titles, special certificates of title, fraud, and the land registry. And we're with Mr. Kaliko Mutima. Thank you for giving us your time and sharing your knowledge with us. So there's a couple of questions that I'll be getting to in the audience. And if you're listening or watching and you have some questions, please drop them in. I'll be able to get to them for as long as time allows. But as I get to that, there's a particular, I want to go back to a special certificate of title, which you just hinted on, because you recently argued that a special certificate of title is not a second title. So would like to know what exactly it is and why does the law allow one to be issued, and how has the process become associated with fraud? Because this is something that Edison has also hinted on. So if you could just pick up on that for the unsuspecting mind or somebody who is non-legal that is watching and listening right now. Over to you.
Thank you so much. I did touch this, but I'll repeat what I said for emphasis.
Yeah.
A special certificate of title is not a new title. Okay? It is a replacement. It is a replacement. The law does give us a replacement mechanism or process, if I may, under Section 69 of the Registration of Titles Act, Cap 240, as amended 2024, as guided, and Section 70, where courts may direct the titles office to issue special certificates. Now, why it is not a new title? I did use this.
That's the certificate of title.
Yes. Elson's title. He was kind enough to allow me use it for illustration purposes. A special certificate of title is a replacement. So every detail on this title must appear on the replacement. The acreage, first of all, the volume and folio, the acreage, property description of the ownership, date of entry, time of entry, all the detail as is on the lost deed must appear on it. So it is not new, it is a replacement. Okay? Number two, like I said for emphasis, the law provides a mechanism. And for the benefit of the audience, allow me to summarize it. Under Section 69, if a certificate of title is lost, obliterated, damaged, destroyed, or unusable, the registered proprietor has a right. It is not a favor. And that is why some people like myself are very disturbed. It is not a what? You're not doing me a favor, but the law mandates that you replace, you give me an avenue to replace this record. So the registered proprietor will apply to the Commissioner Land Registration or the registrars of title. That application is supported by a statutory declaration under the Statutory Declarations Act. Cap what? 24? Yes? 234. Thank you, Alfred. And this is an oath. This is an oath where you are accounting for the loss, supported by a police what? Report. Accounting for the loss. That statutory declaration must be commissioned by a commissioner for oaths. Now, we need to take certain things seriously. That's why I want to stretch, if you allow, I could even jump on this table. Yes, we need to be disciplined, we need to be serious. Why I'm emphasizing oath? Someone has gone on record and saying, I actually lost my what? My title. That law says under section 7, if you misstate recklessly or not, if you misrepresent, it is a criminal offense. 3 years. Yes. 3 years. There is a fine. So the titles office will verify the truth of your facts, and if convinced, will issue a notice. The notice is gazetted. It will run for 30 days. In the Uganda Gazette, in the newspaper of wide circulation, on X, blah, blah, blah. And once the period has run out, the title is what? Is issued. Note, maybe someone in the audience will wonder, so what happens if I have an objection? Because if they're putting you on notice, if you have an objection, you have an avenue. You have an avenue to, you have remedy. You can write to the Office of Titles and they note your concern or complaint. The Registration of Titles Act is a self-contained law. Interestingly, some legal practitioners do not know it. It even prescribes offenses.
Yes.
Yes. Then the Land Act, Section 89, it should be Section 89, talks about the hearing process. If you have a complaint, it has a whole process that you go through. The avenues are contained in the law. Now, if it is under Section 70, if court has directed the titles office to issue a special certificate of title, the registrar will receive the order, verify the same. Yes, the registrar's right to court. That is another mechanism they have introduced. Over time, there have been so many interactions. These, the Elsons, lawyers, stakeholders interact with the office, and the office is doing some work. We cannot discredit them entirely. So they write to court, verify, then a notice is issued still, gazetted, then the title issued. But before the title is issued, you can, if there is an objection, you can apply to court that gave the directive that I have concern ABCD. So there is a remedy for, excuse me, there's a remedy for redress. So that is, I hope I've not over-summarized it. I'm really looking at the clock.
You've done well.
You know, we talk for a living, so.
You've done well. You've done well. That was needed, the emphasis especially, and I believe that is knowledge that is very required and timely, especially that our audience is mixed. We have the legal minds and the non-legals. So there's a question that came in from Jessie, and she's saying, in Uganda, how can a bibanja holder protect their interest when the titled owner suddenly appears after decades of quiet occupation? I could repeat that. In Uganda, how can a chibanja holder protect their interest when the titled owner suddenly appears after decades of quiet occupation?
Thank you. Excuse me. Now, the law does recognize equitable interests. Abebibanja. We have security of occupancy in the Land Act. I think I should stop referring to sections. But the law does provide for security of occupancy. The interest of a chibanja owner is subject to the interest of a registered owner. There has been this jurisprudence to that. But let us first define who a chibanja owner is. Because I believe, and I'm going to pose a question to Elson. Yes, I'm going to ask you questions. This is an area that has been abused. Okay? We have the 1995 Constitution. We have the 1998 Land Act. For you to be recognized as a chibanja owner, the law provides a period before the coming into force
Of the 1995
of
Constitution.
the 1995 Constitution. Now you have a one Muyaka from Budunduli coming onto your land, then they get bones, bury them in the ground, and they say, Nze ndiwe ekibanja, I want to be protected. He who comes to equity must come with clean hands. If you want the law to protect you, and allow me, Elson, I'm going to overemphasize discipline. Recently, I wrote about discipline. We have a discipline deficiency in our country, respectfully, and again, this is my opinion. You cannot purport to be what you're not. So let us first understand who Owechibanja is. That is the law. Am I wrong, Council?
You are correct.
So
who
for
is he?
For you, now I'm asking you the question. That
Okay.
was the first. Am I wrong? No. Am
No,
I right?
You are right, sir.
Yes. So, can you give us your definition of Echibanja owner? Because for me, I've given you mine. Is there any other?
No.
So, for you to enjoy that protection, you must qualify. And if you qualify, the law does allow security.
Of tenure.
Yes, it does.
So
but your
that-
interest is subject.
Just someone may have missed you.
Mm.
For me to be a Chibanja owner, if I'm to be a Chibanja owner, what qualifies me? What makes you say that this guy here has a Chibanja? You are saying is in discipline. It's not a matter of burying bonds and saying I am a Chibanja holder. But so legally, you said there's a period before the Constitution. What period is that? Do you have an idea?
It's 12 years. And there's jurisprudence.
So that's 12 years before the 8th of October 1995.
Yes. Yes.
That's what's mean.
And allow me not.
So that's 12 years before the 8th of October 1995. So a person to say he has a Chibanja, you are saying, must prove that he was on the land on the 7th of October 1983. Am I right?
That is my opinion. And allow me, I didn't want to go into legalese. Many of us confuse adverse possession with a Chibanja interest. They'll say, okay.
Now maybe just you've now brought a new term, and now I know that we don't want to go so much into legalese, but we are lawyers, so we are giving legal views to the public. So there is what we call a Chibanja, or the lawful and bona fide interest is the legal term. Then you have introduced a new term called adverse possession, where you are possessing it adverse to the owner. Then there's what you call a squatter. Then there's what you call a land grabber. Then there's what you call an indisciplined liar. Now, just the legal terms, adverse possession and the Chibanja, just so we can understand, is adverse possession lawful?
Allow me now. I was the one asking you. You have asked me 20 questions, but I'll answer all of them. One, how do these people come onto the land for you to be Owechibanja? You see, land is a very important what? Asset. And historically, it has not just happened today. Everything that we have, our senior colleague Philip Karugaba says this is the main security. The most important factor of what? Production. Even historically. Even from the Bible, that's why we have these wars. I'm not going to go there. Land is very what? Important. So, Owechibanja does not wish it. Now I wish to become Owechibanja. No. Okay? If we look at our history, and you can do your research, we have classifications or categories. We have licensees, where someone comes to work for Deo is pleased with them and allows them to what? To keep on the land. Historical fact. License. Okay? Two,
You stay there on permission of the owner.
on permission. That's why we're calling it what?
A license.
Two, and again using the same line of example. You pass on, okay? Now you have children, grandchildren, great-grandchildren. They inherit what was passed on to you. So you can acquire a Chibanja by inheritance.
Yes.
You can. A Chibanja can also be gifted. Now, I didn't want to go into a certain direction. I see you're taking me there, which is now Buganda and what. I really do not want to go there because that is another discussion altogether. That is another discussion what? Altogether. Because it also falls under this what? Category. But allow me not to go under.
To dodge it.
Not to go under the Buganda.
No, it's okay.
I'm conflicted.
It's okay.
I have the humbling privilege of representing Buganda Kingdom and some of the associated companies, so I will not go there.
Okay.
I'll not go there. I said it's not about politics, so this is not, but where I have conflict ethically, I must declare. So I'm not going to go there. But that falls under that what?
Under that aspect.
But I will not touch it at all. So these interests do not just fall out of the sky. No. They are rooted. They are rooted somewhere. Now, fast forward. Adverse possession. The word adverse. And possession. You come onto X's land. It is adverse because it is without their permission.
Yes.
To put it simply, without their permission.
I can see some guy who is on my land is listening.
I will tell you a story at a later stage. I passed by my own land, then someone tells me, oh, the owner of this land is out of the country. Anyhow. So, without the permission, for a continuous period of 12 years. Limitation Statute, Limitation Act. However, qualification, without any interruption, you are in possession. Without any what? Contestation. I've come to Elson's home. Okay, not your home. Your madam, your wife may get worried. One of your pieces of land, I go there without your permission, uninterrupted, uncontested 12-year what? Period. That is adverse what? Possession. Okay? And we have a number of squatters that fall under that what category. But these terms is really semantics, nomenclature, interchange that. Then the indisciplined ones, allow me go to that category because it is very disturbing. If I had a basement, I would throw them somewhere. These fellows jump out of nowhere, come onto your land, shamelessly. They will get bones and bury them. And they will tell you, "Inze jaja wange bamuzika wano." And they will claim an interest. Before you know it, say, bano abantu ba NRM, bano abanyankole, bano, going into funny, silly stereotypes. At the end of the day, bino byansi byakufa kuleka. It is not about tribe, it is not about what? It's not about color. It's about logic, it's about reality. You're indisciplined because the land is not yours. You're neat without any color of authority.
All
right. Have I answered your 20 questions?
Yes. Very well. So now if you're just joining us, welcome to the Judicial Service Conversations. We are having a masterclass in land law, and we are knowing that most of the people who are not listening, and some of the people who are listening, fall into different categories of people. But ultimately, what we are hearing, there is a lawful and bona fide occupant, what we call the Chibanja holder, who should have been on the land a certain number of years before the coming into force of the Constitution. There is the absentee landlord who loses his land because someone has come and settled undisturbed for, 12 years? There is the guy whose land is just being grabbed by professional squatters. And then there are the categories of conflict that Deo cannot speak to. Joy.
Thank you very much. Conflict noted. We shall do our best to, So this is coming in from Magola. We're still taking questions from the audience, which are quite many, but we'll do our best.
We'll share them.
So Magola says, is the Miloland tenure system still a fair and functional framework for managing the competing interests of landowners and occupants, or has it simply become a tool that entrenches landlessness among the poor while offering the registered owner no real economic benefit?
Yes, it still is. I will note and acknowledge that it has challenges. Yes, the challenges are there. But we need to face, as a Ugandan and as a patriotic Ugandan, I appeal to my countrymen and women, we need to face the challenges. This is a tenure that is created by statute. The Constitution of the Republic of Uganda, the Land Act. Yes, there are challenges, so many. These overlaps that my brother Elson was talking about. Interestingly, most, if not all, Milo land is titled.
Which is a good thing.
Which is a good thing. That is for the audience. However, there are challenges. Right now I'm dealing with a very big challenge in Chira that I should not even talk about here. Where you have so many overlapping interests because of some indisciplined individuals. And I will talk about digitization, maybe manual records. So people took advantage of the dark age. Now we have seen the light, but data is migrated. And for you to have a clean system, the data has to be clean. So if there was darkness, the darkness also ends up somewhere. But notwithstanding the challenges, the system is still necessary. We just need to address its numerous challenges that I will touch as I continue my submission. And the solutions are there. Like I said, plus, most of it is titled. So there's need for data cleanup. There's need for data cleanup. There's need for full data migration. And this is an ongoing process. But at a certain stage, I will tell you that behind every system is a human being. I will speak to that later. Allow me stop there. Next question, please.
Okay, so I'll just do one more and then I'll hand the microphone to my colleagues. This is coming in from a one Kende Sulai. This might be available, but he's saying, why is it expensive to get land titles? I think he's just tired of the whole process. So if you just take him through, maybe he's saying, why is it really expensive to get?
Why it's expensive too?
To get a land title.
Now, we have 4 categories of tenure. And there's a reason why I'm alluding to this. I talked about customary, Milo, leasehold, and freehold. The processes different leading to the title. The costs different. But also, the people you engage to do the work for you. You see, I will not charge as much as my brother Elson charges. My bill may be 50%.
Higher.
Right? But again, we also have indisciplined fellows who inflate these costs. Because I'll tell you, as a matter of fact and principle, the statutory fees are fixed by law. If it is registration fees, you have the 10,000. Now, like these special certificates that you've been talking about, if it is stamp duty, it is 15,000. If there is an extra copy, it is 5,000. If you're transferring land, your Milo interest, stamp duty, the levy, is 1.5%, fixed. 1.5% of the assessed value by the government valuer, not necessarily the market value. Now, there are so many factors at play. So what I would advise the audience, and I'll say this as I conclude maybe, we need to understand what we are paying for. Elson, when you buy land, what are you paying for?
Land.
No. What are you paying for when you buy land?
Title.
No. What are you paying for, Alfred? Beautiful. When you buy land, you're paying for the value. You see, the price you will pay, but value is what you will remain with. So you're actually paying for value. We need to take this discussion seriously. I want to appeal to every Ugandan. The only way we sort out this mess is understanding what we are paying for. Omuganda agamba teka sente wokola ki wolaba. Now, if you're paying for value, then you need to understand the process. There's a time I was at a certain forum. I was in Chicago. I'd gone there to speak. Then this lady seated next to me asks me, Council, mbulira, stamp duty ekyali 10%. I was like, what? 10% of what? That time, stamp duty was 1%. So all these, once compounded, will inflate the cost of the titling. And again, I said the processes are different. If you apply for a lease from a controlling authority, like a district land board or land commission, the process is longer. You're paying you're paying a premium, you're paying ground rent, so the fee is going to be a bit what? It's going to be a bit higher. Same for freehold. If it is a lease out of Milo, well, that one is determined by the Milo owner. So there are so many factors at play. That is why we encourage people to engage professionals, but the right professionals, not the indisciplined ones. Thank you. Next question, please.
If you're just joining us, welcome to another edition of the Judicial Service Conversations. We are talking land, we are talking titles, we are talking property, and we are having a wonderful guest, Mr. Deo Kalekumutima. He calls himself, or not he calls himself, he is the Chief Executive Partner of Kalekumutima and Company Advocates. I think that's a fantastic phrase that we are going to have to steal from you. They are partners, they're executive partners, but you are the Chief Executive Partner. And now one of the people who I know is closely associated with Kalekumutima and Company Advocates is also the Secretary General of the East African Law Society, Deputy Secretary General, in charge of young lawyers. He has been young since he has been young, I don't know for how long. He has to eventually become old. Mr. Alfred Muyaka, who is right here, and I'm going to hand over to Alfred to ask the next questions. I know that Alfred Muyaka has previously, actually, if not currently, been associated with Kalekumutima and Company Advocates. So I don't know, Alf, maybe you should first tell us, for you what, there is a chief executive, for you what are you, but whatever you are, it has been agreed that this is your opportunity to ask Deo as hard and as tough the questions as you want, and everything that you ask him, there will be no impact in the office on any day.
Yeah, thank you, the lawyer's lawyer. Yeah, first I must declare a conflict of interest. Today I have the privilege of hosting my amazing boss. So I'm even able to ask him very questions. He's very amazing. He's a Rotarian at heart. You know the Rotarians who join Rotary.
You're really satisfied with the answers.
Yes, you know the Rotarians who join Rotary to network or what, but that Rotarian of joining to serve. For the people who call me Chivanja lawyer or what, I'm actually a Chivanja lawyer because of his mentorship. He introduced me to land transactions. I don't know how many I've done because of his knowledge, shared knowledge generously. And besides that, he has invested so much in my career, but there was one moment which I want to appreciate, which changed my view of life. For the young lawyers who benefit of the young lawyer series, it's actually me paying forward.
Alfred, this is the second program.
But for the young lawyers who benefit of the young lawyer series, this is actually me paying forward what Mr. Deo does for me, because I can't return it back. Well, the first one, just one moment, we were nearing Christmas one day, and you know those Christmas when you get your envelopes. So we got our good envelopes in Christmas. So because of getting our good envelopes, I didn't even try to worry about whether my salary had been posted or what. So I check, I go, I finish my Christmas. In January, one day asked me, Alfred, how are you young lawyers? I'm like, by the way, I'm broke. Like, why? You didn't get your salary? I'm like, honestly, I didn't get. Sure. So he checks the records. I'm like, actually, I forgot to deposit. Then told me, young man, if I ever reach the second of the new month without paying you, unless I've told that I'm going to delay, please come and tell me. Since then, the money comes and exactly at the end of the month. So, since we're in salary week, you should handle me well. So I really want to appreciate you for the generosity, for the knowledge, for the mentorship, and for allowing me to step on your shoulders. But now, let's get...
No, that's what we wanted, the bat.
Yes, let's get back to Chivanja lawyering, what the land transaction is.
Yes.
So when I saw the post, I was like, someone can still land on paper when I'm the one on ground. They will need to explain to us how that happens. So my first question is related to that one. How can someone actually steal land on paper? We need you to take us through the process of that typical land fraud, from identifying the land, to eventually the land appearing on paper as if it is yours, yet there is someone on ground who is owning that land. Thank you, Council.
Right. Wow, I'm humbled. Thank you so much, Alfred. Very kind of you. Akaranga ako. Sente z'obulango tuzisasula wa. Thank you so much. Now, my views for the benefit of the audience, my views are informed by experience. Okay? Because what I'm going to tell you may question certain things. I'm going to take you through a fraud journey. Yes. But I want to confirm for the benefit. Elson, please confirm that I'm not a fraudster. Kindly.
You know, somebody asked me that now this one who is coming to talk about fraud, is he speaking as a fraudster? I said, no. Lawyers, we speak, we read the law and we understand it. Otherwise, when I advise you how to handle the estate of the deceased, it doesn't mean that I am dead. So I can confirm, without fear of contradiction, that you're not a fraudster, and you are going to take us through the process of what you've discovered in combating fraudsters.
Thank you so much. That is heartening. I'll take a sip. And he sips his water. Now, in land disputes, there's always a story. Initially, the trend was fight for possession. The fraudsters would do their best to push you off court, push you off the ground, because they know once you get to court, the judge is going to ask, or even through the administrative process at Ministry of Lands, the registrar is going to ask you, but who is in possession? So the issue of possession has always been their mastery. But the trend has changed. Unfortunately, fraudsters are very strategic. Fraudsters are very intentional. So they have since moved away from just focusing on possession. They actually begin with information. Yes. And they target their prey carefully. Carefully. I'll give you an example. For the longest time possible, we discovered that police was being abused to ask for certified copies. You know, police would write to title's office, please give us certified copies for this what? Record. Then someone, please don't ask me which police and what. No. I told you this is a logical discussion. Someone goes and gets that record and uses it. They investigate. So the word is, they investigate the actual owner in order to create their fake record and to create a fictitious person as the owner. So they will investigate you. For my diaspora family, at Kalikumtima and Company Advocates, where I'm the chief executive partner.
Yes.
I don't just call myself. I'm the chief executive
Much
partner.
obliged.
We have the humbling privilege of representing diaspora interests in Uganda. We represent the Uganda North America Association, NAUCA, that is Canada, Uganda, UK, blah, 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 blah. So they will investigate and know Elson comes around this time of the year, or actually has never come back. You know, we go there and interact with some of our friends and tell you, I have land in Gayaza. I bought it 20 years ago. Then you ask, which village, sir? Which parish? Ebibia village, Sibimanyi. I never got the opportunity of going to my land. So they will know. Elson stays in the diaspora. They investigate. Then another category of people that disheartens me so much that is taken advantage of, estate property.
Property of guys who have died.
Yes. Deceased persons. There is an unfortunate story that I've just read in the papers that I will not even talk about. They will know, okay, this one is estate land. They will even investigate and know that the family is divided. The beneficiaries do not see eye to eye. Then they will identify one and say, go to for you. tukole bwe tuti. That is another category. Then even companies. For some time now, I give credit to URSB. They have been deregistering companies that are not what? Operation. These fellows also go and investigate companies. They will know, okay, this company has been here for so long. They own this property. They have not been attending to. I have a client who had a property somewhere, a company that I will not mention, big company. They had never, 20 years they have not been to their what? Property. What do you think a fraudster is going to do? So they have mechanisms to investigate. But here is the fear. And I want every Ugandan there to shake. Because what they do now, other than taking over possession and investigating you, they have taken it a notch higher and infiltrated the system, the land information system. They are going to create their falsehood and bring it into the land information system. You will be registered, the fictitious person will be registered on the certificate of title and entry made. Okay? Now, with
then the fraudster is in the Ministry of Lands.
My brother, for you just want to bag tables. I'll get to that. I'm still giving you. This is a movie. I'm still giving episode 1. So, like I said, every system has a human being behind it. I decided to interest myself in cybersecurity, and I'm studying something. I'll not tell you what. Now, every time there's a cyber attack, especially the banks, they're going to, oh, where's the latest technology? We need to get IT. For me, I'm focusing on cyber ethics. I'm focusing on cyber psychology, the human mind. So, behind every system is a human being. I'll tell you, for every fraud that is connected to a system, either cyber or not, there's an inside job. So, yes, they do have allies on the other side. They do have allies. Now, they will create the falsehood, and it is introduced into the records. Now it becomes a cancer. Then ownership will begin what? Shifting. 1, 2, 3 people. Then the actual owner wakes up, Elson wakes up. Oh, I'm back, I've not been home for years. To do a search, there is a 1X as proprietor. Then because the law does provide avenues for remedy, you run, file your complaint, and the person responds. You write a notice of intention to sue. They respond with 2 words.
Please sue.
Please sue. Okay? Then before you know it, that interesting term that is misused that some people don't even understand, bona fide purchaser for value without notice of the fraud. Are you getting the point? This is true story. Very unfortunate. Now the falsehood is in what? The system. Ownership is moving. Okay?
It is cleaned by someone who is allegedly bona fide.
Exactly. So they will create fictitious person. There was a sad story. I'll not mention the area. Very unfortunate. The registered proprietor was killed in courts. You know how they prepare your death certificate?
And even
and get your letters of administration? Yes.
I know the case.
You know the case.
And the man showed up in court and said, I am not dead. I am here. And they asked him for his ID. And he said, now where is the ID of the cops?
What Elson is talking about is a true what? Story. They have taken it next level. Now guess what the innocent Ugandan is doing? That's why we need to appreciate value. That is why we need to take land issues seriously, saying, nze simaina wentandikira bano abantu naye ndowooza ddogo. This is witchcraft. The devil is a liar. Now let me tell you, I'm a Christian. And indeed the devil is a liar. But there are certain things that we say, and I'm sure Lucifer goes like, awompayiriza ekyo sinze yakikoze. You get it? So before, we need to be more intentional. The point that I'm making, these people are determined. So we need to match them. Government has put in place some mechanisms. Okay? No system in the world is perfect. So we need to support these what? these efforts. So their objective, after creating the falsehood, is to have the falsehood put in the system, then transfers are subsequently made in order to authenticate the falsehood. Very unfortunate. That is how land is stolen on what? On paper. But let me quickly give you other scenarios. And that is why we need to appreciate what? We need to appreciate value. You have a one Chibanja lawyer, very excited from the village. They have been instructed. Their understanding of a due diligence is carrying out a land search. They have done the search and told the man, you pay 1 billion. They have not gone to the land, nothing. They look at a title. The title has 1 acre. They say, go ahead. Now, I talked about indisciplined people. Some indisciplined fellows created the intentional errors, where the acreage on the title does not speak to what is on what? On the ground. You're paying for 1 acre, yet on the ground, you have just what? 50 decimals, half an acre. That is fraud. I have a question for you, sir. Can you please define for us fraud? What is fraud, in your opinion?
Fraud. You see, in these judicial service conversations, for example, fraud is when the guest is asking the host questions. But fraud is the intentional perversion of the truth. I think there's a decision of the Supreme Court of Uganda in the case of Frederick J. Zabwe versus Orient Bank, citing a definition in Black's Law Dictionary, stating that fraud is the intentional perversion of the truth. In land matters, it must be attributed to the person benefiting from it. I could go into a more elaborate definition of fraud, but basically fraud is thuggery, it is dishonesty, it is beyond indiscipline. Indiscipline is just disorganization. Indiscipline is losing your title. Fraud is making a new title and finding your way into the system. And fraud is I'll stop there. Anybody who has a better definition, I know one person who knows how to define these things very well. I can see him on. But I'll not mention his name. Yeah. Greetings, Nicholas Opio.
Any perversion. Any perversion of the what? Value. What are you paying for? Okay? So the title has 1 acre. On the ground, you actually have 50 decimals. You called them Chibanja lawyer, wasn't it? The Chibanja lawyer has done his due diligence. Search. Full stop. The due diligence stops there, says, please go ahead and pay what? 1 billion. That is fraud. Then we have powers of attorney. This is another area that has been abused for some time. A power of attorney is basically an instruction allowing X to act on your behalf for a specific purpose and for a defined period of what? Of time. Because if you die, that document also does what? It dies with you. So this is another area that is abused. And we encourage the audience, everybody, the Wananchi, please investigate. We have powers of attorney abused, just like company resolutions are abused, people disposing of company assets. Of course, letters of administration. I may talk about that later. Probate letters of administration have a fiduciary duty. Fiduciary duty, a duty based on what? On trust. You are the legal representative of the state. And you're not necessarily the beneficial what? Owner. Now you have the administrator purporting to be the beneficiary and transferring what? Everything to a certain unsuspecting member X. That is theft on what? I could go on, but in the interest of time, let me stop there. And I also have more questions for you, Elson, but since you've called it fraud, let me stop there.
now we know we can see land on paper. But now this person, he wants to buy land. He has done the search, and he has a search report on paper. Let me say Alfred is the owner. To him, that is from what you are submitting, that person is not safe to proceed to buy land. So if it's not safe to proceed to buy land, what else must that person do to buy that land? And in that same circumstance, you need to also address where that person is buying estate land, because usually people who are abasika to usually when they get land, their first instinct is to sell it to another person. So me who's buying land, any type of land, or where I'm buying from an estate land, what should I do besides just doing a search at lands?
Look for the village drunkard. They're going to tell you everything. No, jokes aside, but seriously, that is now becoming part of the criteria. You must do an elaborate, and I think I alluded to it earlier, you must do an elaborate due diligence. Let me just summarize, in my opinion again, the process briefly. Many people stop at investigating the what? The title. And some lawyers will say, no, but the law is clear. Why should I walk on eggshells? Why should I? You will investigate the title. You must investigate the land now. You must investigate the person selling to you. It is a whole process. So let me just do a quick scenario here. 1, carry out a detailed search. Don't stop at the search statement. These are public records. You can go to Ministry of Lands and appreciate the history of the what? Of the file.
So there is such a thing as search records. There are some people who don't know. What do you mean by don't stop at the search letter?
So in the Republic of Uganda, the law allows you to do a search to find out about the ownership of the land. You pay a search fee, it's just 10,000 shillings. You will get a search statement. I did not carry one. And we also have a portal. In the land information system, there is a public portal. You can go, the fee is very nominal, again, 10,000. It will give you the basic information of ownership. Elson is the registered proprietor, entry this, under instrument this. Now it will display the photo. We must give credit to Government of Uganda, Ministry of Lands. There's a photo. These ministries now speak to each other. The Ministry of Lands speaks to NIRA, the systems were integrated, so you're able to see the photo of the registered proprietor and their NIN. I'm saying this is not enough. You can go to the zonal office and request to do a physical search. If you're saying you're a lawyer in your own right, request to do a physical search, get the file, even write formally, get the file, appreciate the history of ownership. That this was plot 1, it has been subdivided so much, these are the entries. So you appreciate that and also investigate the subsequent transfers further over time. Now, and these processes can be done concurrently. Like I said, we need to take the issue of land seriously. You're paying for value.
Yes.
Take a cent wokolachi sibu. It is not another question for you. In Rutoro we say take a cent mbere okorora. So because you're paying for value, I advise my clients to engage a government valuer. No, not a government valuer. Engage a registered valuer. Do not just base on agents, brokers, and speculators. You're going to go, I'm doing a transaction somewhere, I will not mention the place. There's this small piece of land, small parcel, it's a plot. Structures dilapidated. And the person says, for me, I want 10 billion. And I say, hey, now what is the basis for this? I said, no, that is what I want, it is my land. And indeed, it is their right. But for my client to pay, I'll tell my client, let us do evaluation. Let us confirm the actual value of the land. And also double check it with the government valuer. We have we have decentralization, government zone offices there, government valuers there. Just double check and confirm. So that if you decide to pay above value, at least it is voluntary non-fitting, voluntary assumption of what? You have decided I have the money, let me just what? Let me just pay. Now, while the valuation is being done, you have a surveyor for titled land. Have a registered land surveyor to open the boundaries. This will confirm that the land actually exists, the parcel. It will confirm the boundaries. It will confirm the acreage. That on the title there is 1 acre. On the ground,
It is there.
it is there. And we also, in these processes, we send our enforcement teams. That's when we look for the village drunkards, if any. We look for the churches, we look for the mosques. And we interact with the people. We interact and get as much information as possible. Now, once that is done, you have done your physical search, you have the valuation report, you have the land sub. I'll not go into the other process, it's long. I'll talk a lot more. You have a due diligence report, what? Compiled. Now, I encourage people purchasing land to do their due diligence before they negotiate. Some of you are quick, you run into a negotiation. What are you negotiating without appreciating the value? Do the due diligence, get into the negotiation, have a professional with you. Then from there, you have the drafting done. Someone comes to you, for me, counsel, I've drafted my agreement. It is here. I want you to do a search. Hey, but now, AI. Technology, there's a quick template. Now, your agreement has to be informed by the due diligence process. It has to. Because if there is a dispute, this document is going to help you. So the agreement is not just a piece of paper. This has the terms, very key terms, the covenants, conditions, call it whatever you want to call it. Do you want me to continue? I talk for a living. No, due diligence, I've just summarized the process. And again, it depends on quantum, the value of the transaction. It depends on the tenure. If, for example, it is a lease from a controlling authority, I will not talk about some district land boards. I was about to give a certain example, then I said...
You can use the Chiruhura district land board.
I hope it has been constituted. I'm supposed to do some transactions there. So, if you're doing a due diligence for a land that is an interest coming from a controlling authority, you adjust the due diligence
But
parameters.
controlling authorities are the government district land boards.
You have government district land boards, you have Uganda Land Commission and Kingdom. Kingdom land boards. Buganda has Buganda Land Board. Toro has the land board. Bunyoro, hopefully they have one. I'm sure maybe the Busoga. So there's also a parameter. We check and see. There's a minute that has been, yes, there has been a grant. Okay? But what was the process leading to what? To the grant. Did the area land committee go? No. Did they go
to the land
and inspect?
talk to the neighbors?
And there's supposed to be a report. The neighbors are supposed to what? To sign. There's a sketch. If they did, there's a report. You confirm that was done. Then now you go to the board. Before the board sits, there are also processes. I'll not get into that. I'm going to get into estate land. So you verify that minute, make sure everything is what in order. So
that's the minute of the district land board, for example. Board,
yes. Now, if you're buying company land, you need to make sure the company is up to date. The register, the assets are in order. There's a resolution. If a company is disposing, there has to be a resolution to what? To that effect. Okay? Is it a minority shareholder? Elson is disgruntled. He wakes up and says, now, for me, I'm selling this land. I'm now a one member. If there are powers of attorney, due diligence, parameters adjusted. Like I said, if a donor dies, powers of attorney no more. So you can actually, if it is a power of attorney, you can verify. You tell them, okay, can I please talk to the donor? Say, no, the person is in the United States time zone. You say, for me, I will wait. And make sure you verify that. Letters of administration. We have probate letters of administration where there's a will and the intestate. Now, I'll go to the most contentious, which is intestate, where there's the parameter.
Just for those who don't know, testate and intestate, we were told by Mr. Mtabinga when he visited us that a person can die in 2 ways. That either you die with a will or you die without a will. Legally, those are the only 2 methods of death that are known. And then he told us that if you die without a will, you have died intestate. And if you die with a will, you have died testate. That's what he told us. So when you're talking about this, I think for those who didn't listen to Mr. Mtabinga when he was with us, there are 2 types of death. With a will and without a will. So now you are saying that the most complicated type of death on property is when you die without a will but you have property. Because there are people who die with a will but they have no property. Then there are those who die without a will but they have property. So, yeah.
Okay, I believe at a certain stage I may talk about estate planning and succession planning. But for purposes of due diligence, let's quickly talk about intestate, where you die without a will. Quick due diligence parameter. If you say X is dead, there must be proof of what? Of death. So, a death certificate has been issued by NIRA. So we verify that the person actually what? It's no longer enough to go to, there's a grant from court, the court certified. No, because of fraud, we have taken the notch higher. We'll confirm that the death was there. We are not going to ask you for photos of the burial ground and what. No, we'll confirm that the death is there. Then we move with the trail. Because from there, what happens, a file is opened at Administrator General. Administrator General's chambers have also been decentralized. We have regional what? Offices. So a file has been opened up there. The family meetings have commenced, their minutes, blah, blah, blah. Then a certificate of no objection is issued. So we look for that certificate of no objection to verify that it is authentic. Now, once we have double-checked that, we go to court, get the court file, and confirm that indeed, yes, there's a certified copy, but we confirm that indeed this grant was issued by this court. May their souls rest in peace. We have certain judicial officers who have died. There's a scenario where a grant in courts was signed off by an officer who passed away 5 years ago. Don't ask me where. So that is why we take the notch higher for that. Let me stop there.
Thank you for just joining us. We are live on Twitter and on YouTube. There are very many questions on YouTube, but I'll take some few and give. I will also. There's one from Leon Kevin Odosh, but that one just sends greetings. And there's one from Mugarura Expert Apuli. I think that one should be from Photo. He's asking, does the law adequately protect tenants by occupancy on male land when the registered land owner wants to sell or develop the land? Allow me to combine also it with one from Jordan. How should Ugandans approach the conversion of customary land to freehold or leasehold without losing community rights? Thank you. Can I repeat them? Yeah, please. Yeah. Does the law adequately protect tenants by occupancy on male land when the registered owner wants to sell or develop the land? And secondly, how should Ugandans approach the conversion of customary land to freehold or leasehold without losing community rights?
Okay. I'm going to start with the question on Chibanja. We did tackle that. We tackled that, but I believe the person is just joining us. The law does provide for security of tenure, security of occupancy. My brother Elson talked about bona fide and lawful occupants. But now specifically on sale, this is what happens. If the Chibanja owner decides to sell, they must give the landlord the first what? Right. Option. Yes. The landlord or owner has the legal interest, but this person has an equitable interest that has to be bought out. So they give them the first what? Option. Similarly, if the registered owner decides to dispose of other than saying, I'm selling. The Chivanja owner is not part of your land. But they are not soil. They have an interest, but you're not just, they are not clothes that you're just what? Throwing away. So yes, the law does protect them, and they are also given an opportunity to buy out their interest, to get a legal interest now over their Chivanja interest. I'll stop there quickly to conversion. The law does allow conversions from customary to freehold. You converting from customary to freehold does not mean that you're going to lose your customary rights. Okay? You are securing your tenure further. Now, there has been a debate which I don't like going into. Which tenure is more important than the other? I don't want to go into that, because there are people who do not appreciate customary tenure. You know, we have customary certificates of what? Of title. And some financial institutions, I'll not mention which ones, the credit officers, but now, you know, customary, but this is provided by the law. It is in the constitution of the land. It is in the Land Act. But to answer your question, sir or madam, converting to freehold does not take away your customary what? Rights. You're just strengthening your ownership rights further. It does not. Your customary rights remain. Yes.
Actually, it is a madam. It was Elizabeth Namutos. I think she has land in Fort Portal. So she thinks it may be it may be converted and she loses her customary rights. But over to you.
Taking maybe two or more questions, depending on time, from YouTube. So there's a comment that came in from someone. She's saying women's land rights have improved on paper, but cultural practices and weak enforcement still leave many vulnerable, especially in rural areas. That is a comment. And then a question coming in from Eric says, can a spouse successfully claim interest in land registered solely in the other spouse's name under the Land Act and Constitution?
I beg your pardon, the last question.
Can a spouse successfully claim interest in land registered solely in the other spouse's name under the Land Act or Constitution? The other one was just a comment coming in from that lady. She's noting that when it comes to the women, the rights have improved on paper, but they're still not as effective practically, especially when it comes to the rural areas. I don't know if you have maybe something to comment back, but over to you.
Thank you so much. Now, the gender question is a question, an area that must be approached delicately. But it is my humble and considered submission and opinion that we still have challenges. Gender stereotypes still do exist, and this is from research. I've done research. They still exist. Yes, we have rights under the law. The rights I've been talking about to be enjoyed by both men and women. Article 33, I believe, of the Constitution of the Republic of Uganda talks about rights for equal rights, men and women. Why my tone has changed, it is unfortunate, but there are challenges, especially in the rural. But interestingly, even in the urban, I'll not go there, but mostly in the rural setting. I'm glad that the Minister of Lands is a woman, and she credit must be given where it is due. She has done a good job. We have titles being issued in different places, and in some rural areas, women are actually getting titles. But it's a delicate question. The challenge is still there. Has there been progress over the years? Yes. I believe there has been, but the challenge is still rife. Yeah. Then, no, I think that's it. Yes, there was a question about spouse. Now, there's
Marital land.
Pardon?
Family land.
Yes, family land. There's a test that we use. A test that has been advanced through judicial activism, but also provided for in the law, specifically in the Land Act. To be more specific, it should be Section 40 of the Land Act as amended. Please don't ask me for chapters and... So to answer the question, this is the test. Does that property form or constitute family land? And what is family land? 1, is this a home? Is it matrimonial property? Do you stay there? 2, do you derive your sustenance from that property? That is the test. There is a wealth of decisions, some contradicting each other, but that is the what?
The test.
That is the test. Okay? So you being someone's husband or wife does not automatically mean that you have an interest in their what? In their property. No, it does not. That is the test. Is your home there? Do you derive your sustenance there? Now, the courts of judicature have taken it a notch higher. They also look at contribution. And the contribution need not be financial. Supreme Court, Rabinumi, Bakumbi, and there's a wealth of what? Of authorities. They also look at contribution. Okay? But we also, connected to discipline, we encourage transparency and accountability. Because if you're saying you have married someone, this is your love of your life, whatever, those funny things that people say to each other. Huh? This is my person, this is the person that I've decided to what?
All that I have, I give to you.
All that I have, I give to you. I will take a bullet, they fire a bullet, you're the first person to run away. If that is what you have decided to do, then you need to be transparent. So this is what we encourage. If the property is being purchased, both names should appear on the agreement, whether there is financial contribution or not. Because like I said, contribution need not be financial. 2, both names need to appear on, need to be entered on the title. I've decided to be more specific. This is another topic that we can discuss on another what? Segment under estate. But I've decided to be specific with my answer. It is not automatic. You must pass that test. And where you have decided that you're registered jointly, please be clear. You see, you have a transfer instrument, and you're saying let it have 2 names. You need to know the consequences of that. The law does provide for joint tenancy and tenancy in what? In common. Okay? I'll not go into sections now because of time. If you are joint tenants, unless you specify the percentages, the law will presume for you that they are equal what? Shares. And again, the doctrine of survivorship will apply, that if one of you dies, the surviving partner will become the sole what? Registered proprietor. However, even where you're registered, and that should be section 53 or 54 something, even if you're registered as the joint tenants, an entry can be made and clearly stipulates no survivorship. So then the doctrine of survivorship, yes, it is there in the law. Would you like me to address you in the law? It is there. Let me help my son. Open the RTA. It should be section 53 or 54.
But just so that, if you're not a lawyer, so that you're following, maybe I'm going to just do a little bit of term definition. There is no survivorship. There is joint tenant. There is tenant in common. The idea is that if you own land on the title, you're 2 people. You say, for example, you are Alfred and Muyaka, and assume those are 2 separate people, or Joy and Mbabazi, or Hope and Matsuko. Let's say you're 2 separate people and you are on the title together. He's saying that if you are joint tenants, that means if you do not have the word tenants in common on the title, and you both appear, and one of you dies, Your children do not take the land. The land goes to the other guy who is on the title. All of it. I think I've got you. I've understood you correctly. A bit. Okay.
Spot on.
Yes.
Spot on. Thank you so much, Elson. For the benefit of Alfred Miak, Section 57 of the Registration of Titles Act, Cap 240. Effect of insertion of the words no survivorship. If these words are inserted or entered
On the title.
on the title, then that doctrine, what he has just alluded to, will not apply. That would mean that the children of beneficiaries will be entitled. Now, if they insert the words tenants in common, the respective estates, so you have A and B. A passes away, B is surviving, but B is also the wife of A. Okay? A split is done. The estate of A will be entitled to their share of that land. And B, notwithstanding the fact that they are already a registered proprietor, if they qualify as a beneficiary, they will also get their entitlement by virtue of being beneficiary in the estate. Sindio?
Yes.
Yeah. I think now we need to move faster because of time. Yes.
Another one from YouTube, their comments, people appreciating the knowledge being shared, and they say this saves them from a lot of back and forth and, some bills there. But James is asking, can someone get a land title with a plot of 20 by 50 measurements? And then the other one is asking if you could briefly talk about caveats. I think we'll just take these two and then I'll hand over to Ellison. Oh, I'm so sorry. X was muted, pardon me. And I'm told even the previous bit. So the last bit he was talking about, someone left a comment on YouTube. We're taking questions from the YouTube audience. So he hinted on women's land rights because somebody says there's an improvement on the the rights for the women, but it's more or less on paper, and in actual sense it's actually limping when it comes to enforcement. So he handled that. And somebody was also asking about marital property, that is if land is registered in the names of one partner. So that's what he covered. And then the question that we're putting to him, just the last two, is coming on from James, who is asking if someone can get a land title with a plot of 20 by 50 measurements. And then another person is asking him to briefly talk about caveats, and then I'll hand over the mic to Ellison. Over to you.
Thank you so much, Joy. Now, to the best of my knowledge, there is a practice or a guideline that says titles are created for parcels. A parcel is a plot. These are words that colonialism, these are words that we took on. A parcel is what? Is a plot. You'll see it on the title. So, to the best of my knowledge, the titling is done for a plot onwards. That's 11 decimals plus. But the law does not expressly say that you cannot get a title for, say, 5 decimals. Why the guideline, I didn't carry it with me, but it is there, because I've had scenarios, especially when I'm doing work for government. If you have key installations, say National Water has a water reservoir, and this has to be titled. Even if it's 5 decimals, you're going to what? Title it. This is a key installation. I've encountered it with key installations. To avoid absurdity, that's why the practice was introduced. Otherwise, you'd have people saying, I want a title, I have 1 decimal. Now, let us not confuse this with residue. If you do a subdivision, waliwo akasigalawo arohaka kusigalawo sindio waliwo ka balance that is the residue remains on what? On the title. Now the scenario that we are talking about is where you're titling, okay, no, we are not talking about a residue, you're titling 1 what? Decimal. So the law may not expressly bar it, but the practice does. Because they are going to, if those of us who do work for certain institutions, they are going to ask you so many questions. So tell us, you're saying, you say, yeah, I need it titled. This is a key installation. So you're going to have to do a bit of explaining, if you know what I mean. Yeah. Then caveat. The law does provide for redress. So a caveat is an encumbrance, a roadblock that the law created to protect ownership interests. But it is a temporary relief. It's not permanent. You cannot put a caveat and think this is it. Caveats can be removed. That is why when you place a caveat on X's property, this is what happens. You're going to make your application. X is going to be notified that Deo has put a caveat on what? Your property. Why they notify them? The law allows X to object, redress courts of law. Okay? This person has put a caveat on my land, but he actually has no interest here. Let me give you an example. An area that is often abused. Again, estate land, they're going to be able food. This is it. In their life, a registered proprietor lawfully deals with their property. Then a great, not a son, Elson, a great grandson comes up and says, no, my great grandfather did not deal in the property, and puts a caveat. And if I may, beneficiaries' caveats hold. It is not like an ordinary roadblock. This one has extra concrete. If I may oversimplify, we said this is practical discourse. So for you to remove a beneficiary's caveat, you must demonstrate that one, the estate was already distributed. This beneficiary got their share, and it is not this one. So they actually do not have an interest here. Or their interest was determined maybe by due process like what? Like court. And it is an area that is abused. Now there's something, Alfred, I have a question for you. Do you know that the law allows you to sue for damages if someone wrongfully puts a caveat on your land? The audience there may not know it. If a person wrongfully puts a caveat on your land, you can sue them for damages. Because we said we need to take land issues seriously. We need to understand value. So you can sue them for wasting your time, for inconveniencing you. Yes, this is sabotage. We are saying the Constitution is giving you rights. Now I want to sell my land to check. The prospective buyer is telling me, oh, Joy put a caveat. Caveat, what is Joy claiming? So yes, do you get the point? So the law does allow you, it gives you redress. It's an area that is also abused, but because of time, let me stop there. Next question, please.
Okay. If you're just joining us, we are almost winding up. We have 5 minutes to go. I think it has been a fascinating conversation. I'm going to ask you, there are so many questions. I saw someone asking about, I saw someone saying, okay, so there's a special certificate of title. So what happens if they are both there? Which one is the title? If somebody shows up with the title and then there's a special certificate of title, what happens if they're both there? I saw someone asking all manner of questions, but unfortunately we're not going to go into all of them because we have only 4 minutes to go. They have introduced fascinating topics here. This issue of survivorship. A lot of estates and disputes are happening. Someone says, this is my father's land, and the other person says there's actually no survivorship. Your father did not put the correct protection on the title. People have asked you about spouses. The law is very clear. You cannot actually, even the tests you said, I think are controversial, because if you read the Land Act, there's a section which says anything which the family considered to be family land can easily be family land. So the family can actually just say that, no, this was our family land. I once had a case, a senior member of this society came to do a land transaction and borrow money, and he came with his wife. but I knew his wife. And she was not the one he had come with, but this other person was claiming to be the wife. So you have all these very intricate things, and then you have really the danger, because land is actually a specialized, complicated, deep area of law that touches people. I mean, principles like survivorship, principles like the actual interests and power of a spouse, the community and communal land issues, issues to do all these land issues. And then you have backlog. You have judges who are actually completely able, or some maybe not, who have a proper understanding of the area of land law. So I want the last question to be 2. The last question is not those ones that, maybe those are the people asking, but you have like a minute to answer them. But also, overall, your take, because we have in my view, we have a challenge of the courts actually being able to understand the law, to resolve the issues, and to resolve them quickly. Crime, if I can just wind up, crime is really fueled by land. A lot of crime in this country is land fueled. Trespass. Offenses like, there's an offense called malicious damage to property. There's an offense called trespass. Even many of the assaults, many of the murders are actually driven by a failure to have dispute resolution on land in accordance with the law. We have RDCs enforcing things as complicated as survivorship, things as complicated as spousal consents, things as complicated as communal rights. So I just want your take on that. We have always had a suggestion, but I won't disturb you with that suggestion. And then I want you also to really give us your parting shots, your bird's eye view of the land situation in Uganda.
And a song.
And
Also
then you
a
will
book.
also tell us a book you are reading and a song. The song must really lift our spirits about. I know you're thinking of Dolly Parton, but anyway.
No. My way, France, that I hope it will be played. So, again, a marathon of questions. Now, I'm going to be a bit fast. Let me quickly address what the audience talked about. Special certificate of title, and the other one exists because it is an area that is used by fraudsters. Once a special certificate of title is issued, it takes precedence over the duplicate. It does. So what happens if you have lost it, you return it, the duplicate is cancelled, and if there are any entries that are not accommodated here, they have to be updated accordingly. You're not supposed to have two certificates of title over the same parcel. Just like you're not supposed to have two competing interests over the same what? Plot or piece of land. You cannot have freehold and milo on the same what? Land. Excuse me. Now, you have summarized the challenges of land administration and what? And management. These are my 2 cents. We have governance issues. We have enforcement challenges. We have indiscipline. We have budget issues. So I'm going to touch each very fast. Enforcement should be left to the people who are supposed to do it. I'll give you an example. If it is the role of police to investigate, let police investigate. If it is the role of DPP to prosecute, let DPP prosecute. If it is the role of the judicature to adjudicate, let the courts of law adjudicate. Okay? An RDC, and I'm glad that we have the Constitutional Court decision. An RDC, God bless Justice John Mike MCC. An RDC who's not a lawyer, and even if they were, is not a competent authority to start questioning a decision of court. If you're not contented with the decision of court, go and what? Go and appeal. So the RDC is not, yes, the intention may be right, but is not the right what? Forum to do that. Let us empower. If we are going to sort out land management issues, let us empower existing structures. I'll give you an example. We have should be Muchivi decision Supreme Court. It says the Commission on Land Registration does not have the mandate to handle fraud because they do not have the parameters. That is true. In Kenya, benchmarking. Our neighbors, the Commission on Land Registration has the mandate to do so. So how can we reinforce these existing what? Structures. You talked about case backlog.
Yeah, suspicious of ours.
In Uganda, we have over 162,000 cases. We're talking about divisions and division. Case backlog, over 42,000 cases. Pending case loading, over 27 That is why we are advocating for alternative dispute resolution. I commend the Chief Justice of the Republic of Uganda and the courts of judicature because they are pushing the agenda. Let us have alternative dispute resolution to check this. Is it enough? It is not. We have a lot of money stuck in the courts, but at least this is a step. Then additionally, merit. We need to bring back merit to our institutions. We need to. You and I are government. Who's government? Government is not a minister. You and I are what? A government. You want to bang the tables, let us bang them. Don't just keep quiet. Let us bang them intellectually. That's why I'm here to have this discussion. That is why I write. We cannot keep quiet. We need to bring back merit. Budget. Ministry of Lands collects a lot of money. Do you know their budget allocation? It is not commensurate to the money that is being located. You have a department of land registration. Is it empowered enough? The last I checked, our colleagues, there's a time some years back a registrar was earning 600,000. These are lawyers, these are advocates. Now, poor fellow, you're giving them a transaction, a mortgage of $20 million. I'm not saying it is a justification for doing a wrong thing.
I know one was earning that per transaction. But anyway.
The point is, we need to empower. Now, I told you the RTA is self-contained. It has offenses created.
Yes.
Let us prosecute these fellows. In Ghana, there's a database for rapists. Create a database here for fraudsters. Yes, create it. Then every fraud you'll hear, oh, there's someone in government, is someone in government. I'm not even going to go there. Some of them are allegations, but some of them are true. Expose these people. I'm glad that General Saleh, good man, in my opinion. I have my reasons for saying that. Some people may not like him. People are always accusing him of land. He introduced a land bank. So other leaders should also come up where you're being accused. Come up. Don't just deny that you're not involved. No. Come up now to guide the wananchi in the right what? In the right discussion. Now quickly, as I summarize my parting shots. When you buy a property, you need to think legacy. I hope the next discussion we shall be talking about estate planning, succession planning, business continuity. You need to think legacy. You need to think about the next generation. Don't just think about yourself. That's why you need to appreciate value, manage the property right, create the wealth, preserve it, transfer it to the next what? Generation. We need to take land issues seriously. We need to stop taking them what? Casually. For estate planning purposes, you must plan, you must document, you must communicate. Do not fear to have these difficult discussions with your children or your wives or whatever you want to call them. Tell them, for me, this is my property. This is how I wish to deal with it. Testamentary freedom has gone away. Someone leaves a will and someone says, no, he couldn't have thought that. Are you in his head? Who are you? Are you a psychic? Yes. These are very serious what? Issues. This is part of the indiscipline that I'm talking about. We need to think legacy. We need to take these issues seriously. A book for you, The Psychology of Money by Morgan. Look for it. Then the song, My Way by Frank Sinatra. Because if you've worked so hard to create this wealth, you must do your best to make sure that you protect it and it transitions properly. Even when you are away, let things be done your way. I dedicate to you My Way by Frank Sinatra. I want to thank you wholeheartedly.
Thank you. If you're just joining us, as we always say on these judicial service conversations, you are late. It is our honor and privilege to have had with us Mr. Dewo Kalikomutima, as he has come in what I think is a highly specialized, deeply technical, highly emotive area of the land, of the law, and that is the law of land. And the questions, I think you've handled: security of title, security of tenure, integrity of the registry, quality of our land administration, the ability to resolve disputes. I think it's been a fascinating conversation in many ways, and it is so clear to anyone listening that we have barely touched the surface of this issue. And I want to close it with my own views, to take the liberty of giving my views in the last 2 minutes. And to say that for me it goes back to an issue that we have been passionate about, which is the issue of case backlog. A large amount of case backlog in this country is land disputes. Land disputes are taking 3 to 5 years to resolve in Uganda. That level of complication. Just understand what is the law and how is it enforced. Who enforces it? How do you make sure that what you own is actually yours? When is it possession? Is it force? Is it? And I think criminal. If you remove the land aspect from succession, that is inheritance. If you remove the land aspect from criminal, if you remove the land aspect even from corporate and commercial transactions, you'll have a problem. So I want to end with a suggestion that apart from understanding the rights of the land law, that the government should adopt the suggestion we have made here. You talked about alternative dispute resolution. That is not the solution. It is okay, it is a solution. We think it is very good. But the real solution is what we have been saying with our friends. I know they are annoyed of us these days. But our friends from Law Society have also been saying it with us, which is the issue of appointment of mission-based judges. We must take a year or two to sit down, pilot it in land, sit down and say we're having 50, 60 new people to sit down for 1 year and look at resolving land disputes in accordance with the law. Let us churn out judgments and decisions. Survivorship, spouses, Bibanja versus registered title, evictions, etc. You have really opened our minds, touched the surface, blessed our hearts. You have done the real Rotary. You have done service above self. And for that, we are really assuring you that although you think it is your way, the way you are suggesting, I want to suggest and submit that the solution to this problem is nothing short of cackling the bull by the horns. In my view, the biggest problem in the justice system is the justice system's ability to resolve land disputes. And that failure is what has given room to RDCs. RDCs were not the problem. Courts were, frankly speaking, because decisions were not coming out in good speed. With those many words, I think I want to suggest that it is my way. Article 142.2, appointment of mission-based judges. Over to you, Alfred.